मुझे मालूम है These appeals are at the instance of the state of West Bengal and arise out of two prior rounds of litigation wherein the state suffered judgments against itself. We have extensively extracted the relevant submissions made across the bar, and we have of the considered view that certain questions which arise for consideration, there are 13 in number, which we have, which we'll read. What is the scope and extent of the power under Article 309 of the Constitution of India? What is the scope and extent of the rules framed by the apparent state, that is ROPA rules, and the first memorandum dated 23rd of February 2009? Whether the notifications official memoranda issued subsequent to the clarificatory memoranda dated 23rd of February 2009, that is 9th of December 2009, 6th of April 2010, 23rd of October 2010, 12th of December 2011, 31st of December 2012, 16th of December 2013, 9th of January 2015, and 14th of December 2015, issued by the apparent state revising the rates of DA are in consonance with the ROPA rules. Given that the definition of existing emoluments in ROPA is identical to the central government rules, that is legislation by incorporation, could the state have then deviated from the index being adhered to by the central government? In other words, was the incorporation of AICPI number a one-time measure? Whether DA as a concept is static or dynamic, and whether by the act of the legislation recognition of a particular index does the character thereof change? Whether the actions of the apparent state are vitiated by manifest arbitrariness, as also negatively affecting the legitimate expectation accruing in favor of the employees. Whether adoption of the AICPI would render the distinct legislative domains under List 1, Entry 70, and List 2, Entry 41 OSHO. What is the impact of the direction of the tribunal for the state to follow the AICPI insofar as the financial autonomy of the state is concerned in the federal structure of the country? What is the effect of the findings returned by the High Court in its first round of litigation? Do the respondent employees have any right to receive DA twice a year in line with the pattern of the central government? Is financial capacity of the state a ground available to deny the payment of DA if under the existing rules the same is held to be a legal right? Since the question involved in this list is the payment of DA, which is an aspect of fiscal policy of the state, what is the extent of judicial review which is permissible? Can DA be said to be a fundamental right under Article 21 of the Constitution of India as held by the High Court? The claim of the respondents is for a period 2008-2019. However, the legal redress of the alleged grievance was only initiated in 2016. Was the claim of the respondent affected by delay and latches as such liable to be dismissed? Now, these are the questions which in our considered view, which arose for consideration before this court. And we have answered one by one. We'll just briefly, we understand this morning, and we also have to go to the court, but we'll tell you. We have said that Article 309, we have extensively discussed, and the principles enunciated are non-exhaustive. One. Questions number 2 and 3, we have come to the conclusion that In sum, it is thereby concluded that DA by its very nature is non-static, fluid, and subject to change. How that change is to be carried out is through the ASCPI. The first memorandum is also the subsequent memoranda fall prey to the fatal flaw that they do not make reference to the ASPI, which is absolutely essential to the determination of the DA, which in turn is indispensable to the computation of the total amount of existing emoluments. As a necessary follow-up thereto, it would be observed that the incorporation of the CPI cannot be termed as a one-time measure, and once DA was defined using it, to take a different path would be impermissible in law. So questions 2, 3, 4 are answered accordingly. Now, insofar as question 5 is concerned, it has got two facets as we read. One is with regard to the arbitrariness on the part of the state, and the second is with the legitimate expectation of the employees. And all these, on both these issues, we have said that keeping in view the judgments referred to above, the principle of manifest arbitrariness under Article 14 refers to legislation that is capricious, irrational, lacking reason, principle, or excessive and disproportionate. Such arbitrariness vitiates both subordinate and plenary legislation alike. In the present fact, since the legislative exercise did incorporate ASCPI into the framework, deviation therefore from without any basis or discussed however falls in the lacking of reasoned principle prone to manifest arbitrariness passed from legislative competence. For the apparent state to have deviated from the recognized position to something else without laying the groundwork, therefore compromises the exercise of rendering it capricious. So that is what we have read. Insofar as manifest arbitrariness is concerned, we have further elaborated, and we have held that it is not so in view of Hakamchand Supra, which you had referred to. And insofar as legitimate expectation is concerned, we have said that, of course, it cannot be unless it is by rule of law. And we are of the view of that in the light of the principles referred to above, the legitimate expectation on the part of the respondents did arise in view of the change in the position of law. Otherwise, there is no legitimate expectation. Enactment of ROPA and its recognition of ASCPI as there is any conflict in between the list 1 and list 2 of the schedule. We are of the view that this question does not arise in our considered view at all, and therefore we have said that there is no conflict. These both are coextensive and working in a totally different plane. So, then the next question we have said is that the alleged conflict in our considered view is a figment of the imagination of the apparent state. The argument seems to have been conjured up in thin air. Where is the exercise of the power of the union, legislative and executive imposing any conditions of the apparent state? On the contrary, the power exercised is only by the apparent state through the governor, permissible under the constitutional scheme in terms of Article 309 of the Constitution of India. Now, coming to the effect of the finding of the first round of litigation, we have said that yes, it has conferred a right on the employees. Whether the respondents were entitled to DA twice a year. Here we are in agreement with the submissions made by the appellants that DA cannot be given twice a year. So that to this the appeals are allowed. Now, fiscal policy and judicial review. We have elaborately discussed that once there's a right which is conferred upon a person, then fiscal policy cannot be come in the way of the disbursement of such rights. Now, whether dearness allowance is a fundamental right, we have said that in terms of the impugned, because it was not given up really, in terms of the impugned judgment, the High Court held that payment of DA was a facet of Article 21 of the Constitution of India. Before this court, however, the opposing parties have jointly agreed that none will press this question either way. That being the accepted position, we do not give any finding thereupon and leave the question open to be decided in an appropriate case. So the appeal is allowed to that extent also. Now, whether there is delay in latches, we are of the view that the employees have been relentlessly pursuing the matter before different fora. So therefore, their legitimate claim, which is recurring in nature, we're giving a fresh cause of action every moment, cannot be said to have been delayed, cannot be denied on account of delay in latches. Now, the directions part we have read is this. Apropos to the above, we pass the following order. The appeals are partly allowed on two issues. To receive dearness allowance, page 128. To receive dearness allowance is a legally enforceable right that has accrued in favor of the respondent employees of the state of West Bengal. Given its incorporation in ROPA rules, the AICPI is the standard to be followed by the appellant state of West Bengal for determining of existing emoluments. The employees of the appellant state shall be entitled to receive the arrears in accordance with this judgment for them from the 2008 till 2019. On 16th of May, we had passed following interim order. We have extracted that interim order where we had said that some amount be immediately dispersed. The interim directions issued are herein shall be complied with immediately. On account of subsequent change in law, if any amount that would be dispersed in compliance with the judgment shall not be liable to be recovered. Considering the financial implications involved and also recognizing the need for structured release of the funds so as to not prejudicially impact state's exchequer, while at the same time balancing the rights of the employees to receive the emoluments due to them, we find it fit to constitute a committee to monitor the implementation of the directions herein above as follows. We have requested Honorable Ms. Justice Indu Malhotra, former judge of this court. We have also requested Mr. Trilok Singh Chauhan, former Chief Justice of Jharkhand. We have also requested Mr. Gautam Bhaduri, also a judge of Retired Judge of Chhattisgarh, and along with them, the Comptroller and Auditor General of India, or a senior most officer in his establishment nominated by him. The import of the committee shall be in consultation with the state authority to determine the total amount to be paid, schedule of payments within which the state shall be bound to follow, periodically verify the release of these amounts. The exercise to determine A and B shall be carried out before 6th of March 2026. The next consequential step, that is the payment of first installment, subject to the determination of the committee, would be paid before 31st of March 2016. The committee shall be accorded all facilities and privileges, including all necessary logistical arrangements. Expenses shall be borne by the appellant state. Insofar as the remuneration is for the committee members is concerned, we leave it to the wisdom of the chairperson. It stands clarified that those employees of the state who have retired in dependency of this litigation shall also be entitled to benefits in accordance with law. Let the appellant state, after payment of first installment, file a status report indicating the determination made by the committee, the schedule adopted, the status of the first payment, list on 15 May for compliance. These pending applications also stands.
Grateful. Very good.
My lords, the employees are extremely grateful.
We'll only say we have rendered justice, that's all. Right or wrong, good or bad, we don't know.
Actually,
chairperson लिखा है ना
grateful.
Thank you,
Very.
But for you, we wouldn't have been able to, and my lord's contribution. Largely.
Your lordships have burned the midnight oil. We have only worked around 10 p.m. or 11. Your lordships.
No, you have also burned midnight.
You don't know how much my lord
effort
had to,
we appreciate, my lord. We know.
Grateful. Very good. Very
Thank
good.
you. Thank you.
Item 1501.
For the reasons recorded herein above, we are of the considered view that the impugned judgment is reasoned and borne out from the material on record, except to the limited extent expressly modified therein. This court does not find any ground to take a different view from that taken by the High Court. Accordingly, the civil appeals are dismissed.
Thank you.
Item 1.
Lord, Your Lordship begins the bench. Lord, that British motor case, that 104 is wrong. They said, yesterday Lordship adjourned it to 17.
We realize that it has to.
Lordship may direct the registry to,
We'll do that. I think the order needs to be corrected.
yes, because it has gone to 17 because Lordship is sitting in the combination.
Order needs to be. Today it is listed, na?
104 it is this.
Ma'am, just wait. Just can you wait? Right.
I'm in your Lordship then. I just
we'll
want to
do
bring
that.
it to your Lordship notice.
We'll do that. What we are saying is that the item comes.
Yes, we'll do
You are
that.
here only.
Yes, my Lord.
You are one of those
It is a pleasure.
who never leaves the campus of the Supreme Court. just.
It is a pleasure, my Lord.
Your affidavit have you filed?
Yes, my lord.
Affidavit.
On 2nd of February, my lord.
Malords, we are,
Very short affidavit I have
we
filed.
give, Malords, we undertake to Malords, provide the requisite undertaking before the jail superintendent in terms of the affidavit.
But I fail to understand why a 32 and why a writ petition.
Malords, because there are multiple FIRs.
It's okay.
in
You
different
have
places.
been granted bail in number of cases.
Malords, otherwise, Malords,
Otherwise, this will become a trend that file a 32 petition and get bail.
Malords, in this matter, Malords, because I would have been required because of the medical condition.
No,
it
yeah,
was an
recently
emergency.
I was going through this order 212024. You have been granted bail in one case.
That's right, Your Lordship. But in this case,
No,
Malords,
so
I
why
would
to
have been-
bypass that remedy? Then it will become a trend. Everybody will file a writ petition, get a bail, and then if that petition is dismissed, come to this court
Malords, we went in 226 only for this reason.
for bail.
Pardon?
For bail.
Malords, we went, Malords, only for this reason that at 4 different places, I would have been required.
How many FIRs are there against you?
Malords, total Malords cases in which Malords I am in custody, total FIRs are 21, in which 9 I have been acquitted. 12 are the pending cases.
And in 12, how many cases you have?
8 bails I have already got.
So how many are left?
Only Malords 4 matters.
4.
I
So
am
you
in
can,
custody.
if the court has granted you bail in 8 cases, 4 again the court will grant you if there's no material.
Malords, I will be required to Malords go to Chittorgarh, Malords Pali, Jaipur, and Malords one more place.
The interim bail is for how long? For what period?
Malords, we are requesting a lordship for 3 months.
3 months medical treatment for 3 months.
Malords, because I am the only Malords parent available.
One. According to you, What is that you say?
Lord, if your lordship will have this affidavit dated 2nd of February, my lord. 2nd of February,
Yes.
very short affidavit on behalf
No,
of the state.
where you have said that he will furnish the details of the hospital where his wife will undergo treatment surgery.
Age
Uh,
3 months.
What, so what is the period which you have suggested here?
Period, any reasonable period, whatever you have said. On period, I have not said anything.
Maximum surgery will take how much time?
My lords, surgery will not, my lords, it's a post surgery, my lords, recovery will take, my lords, about 2 months.
No, what we'll do is we'll give you 4 weeks time for this. And should there be, depending upon the further requirement, then you move an appropriate.
My lords may have it for 45 days, my lords, for the reason that I am the only parent, my lords. My parents are not alive, my wife's parents are not alive. There is nobody in the family.
We have perused the
Your
affidavit
lordships
filed
may
by the
take 45
state.
days.
We have perused the affidavit filed by the state. In principle, state has no objection to the grant of interim bail.
Only on medical and humanitarian.
In principle,
Yes, ma'am.
for the reason that petitioner's wife has to undergo undergoes surgery,
And there is a 11-year-old child, you know.
and there is none else in the family of the petitioner to attend to her. More so when there is a 11-year-old child born through the wedlock. In these attending facts and circumstances, we allow the application in the following terms. A, the terms and the conditions set out by the terms and the conditions as the state has referred to in para 5 of the affidavit shall be strictly adhered to. The interim bail, the period for interim bail shall be for 45 days from the date of release. The petitioner, during this, we clarify that the protection is granted, that the liberty is granted only for the purposes of the treatment of treatment of the petitioner's wife, who has to undergo surgery on account of personal ailment. Then after the expiry of 45 days from the date of release, the petitioner shall immediately surrender.
And my lords, conditions be subject to the satisfaction of the jail superintendent.
The petition shall be, no, petitioner shall be produced with the concerned magistrate.
Consent budget.
Magistrate
On.
for
Then my lords, it will require 4 different men. That's why my lords, I was jail superintendent.
Court to fulfill these conditions, my lord.
no conditions of the jail superintendent.
I am going to comply with all the conditions and I will
That
give my undertaking in terms of the conditions given in
Jail
here.
superintendent, and petitioner shall file an undertaking before this court to the effect that he shall comply with the terms and conditions part of the order.
As a lord.
Very good.
Please, sir. Item number 2, I appear for the petitioner. Was in this matter, service is complete on the whole respondent, but as per the office report, no one has entered appearance. Lords, in this matter, I was non-suited on the ground that under the Chhattisgarh Commodification Act, my husband doesn't count as a spouse under the definition of member of the family. So the case against me is that I have created a subtenancy in favor of my husband. But husband is a protected member, my lords. He's the spouse under the definition of member of the family. And on the second count of bona fide requirement, the plaintiff already has 2 other shops in Mahalakshmi market in the same area. And one shop he has already sought evictment against.
Subletting, you may be right, because the definition of 2B includes spouse.
Yes.
But as far as the bona fide requirement is concerned, you see,
It's his choice.
Milos, but I have a certain protection under the Act from evictment.
you take time to okay it. How much
You are
time?
there for the last 21 years.
Please,
It's
Milord.
not your property.
Please, Milos.
Please leave it.
Milos, then in
Please
that
vacate it. No, no.
6 months' time may be granted. I'll evict. I'll
Six.
All
close my
right.
business.
Fair enough.
Undertaking.
Please. Grateful. Thank you.
Your good name, please?
Advocate Namrita Chandorkar.
Namrita.
Yes, sir.
We are from my state.
Yes,
My
sir.
undivided state.
Yes, sir.
The lot belongs to the entire country, my lord.
No, but see, all fingers are not equal.
No.
Bias towards.
1 minute. Now, my lord now has to give relief to him.
Why is it Madhya Pradesh?
Unfortunately, my lords, the stage of granting relief today will not come because the state is taking some time to come back with a bit.
No.
So,
Let us see first.
They filed an affidavit.
very good. So my learned friend just told us that, my lords,
No, there was
they
something,
are
but
withdrawing their affidavit.
No.
That's fine, very
Didn't
good.
say that. I'm not
Very well.
going.
Better for us.
Your lordship had asked certain queries on the last date, your lordship, and I had given a affidavit in this regard.
Maybe I'm taking time.
So the number which has come up, your lordship would have page 3, paragraph 4, where I have just given the list of the query which was raised on that day.
This is which one? Which affidavit?
We
3-2.
have filed,
3-2.
yes,
Yes.
affidavit on the, this is the 1359, SLP Civil 1359 of 2023.
There are how many vacancies?
Yes, your lordship. Now, if your lordship would have paragraph 6, that the total vacancy of 7129 posts and the category wise detail was given in paragraph 7, paragraph 6. Then in paragraph 7, it is stated that there was total vacancy of 3546 posts of home guard and the category wise detail is as follows. Then in paragraph 8, it is said that out of the vacancy of 3546, the total vacancy seat filled for all category of home guard is 297. Total women seat filled with home guard is 6. Total women seat unfilled for home guard is 116.
Such hardly 300 people.
Yes. These are the seat, but your lordship, here what the case before you, your lordship, is that they are not having requisite qualification.
No, I was not able to find anywhere. This statement of yours is not in the main judgment. The issue was filling up of the vacancies which could not be which were not filled because of want of home guard candidates to be given to them. That was the issue.
Your lordship, the finding also says that the minimum requisite mark, the cutoff mark was 169.
No.
I'll show that.
That's
The cutoff marks was 169. The marks obtained.
Please show it from the
Please,
judgment.
your lordship. What judgment?
I could not find that line.
Judgment is about-
Absolutely right. The question is about minimum eligibility, which all of us clear.
Show your lordship.
No, it's cut off. Cut off.
As
Will
per
bear
the
with us.
advertisement
Now, my lords,
that-
now that my learned friend is going ahead, allow me to address it. Now, my lords, what had happened was this, and the infirmity in the order.
May I just
My
complete
lords,
your lordship?
no, I am addressing the court.
We followed your cutoff issue.
Okay.
But insofar as the minimum eligibility is concerned, every candidate which is before the Supreme Court has minimum eligibility. Those people who do not have, I'm giving it as a caveat, those people who do not have minimum eligibility are not entitled to come in. I'm not claiming for them, first of all. That's the fair submission that I'm making. Second thing is this, that the High Court has messed up, my lords, by confusing the cutoff with the minimum eligibility. Now, cutoff, my lords, is a dynamic concept. If there are 50 seats only, there are 500 people, the top 50 candidates, the lordships are right. Now, my lords, therefore it keeps moving. There were more vacancies. So if the vacancies are increased, the cutoff is bound to fall, point number one. The vacancies in this case exist. The rules say that if there are vacancies in the home guards and in the women reservation, they will have to be filled up in that year. That is the law. That is what the rules are saying.
No, that is not.
Their own counter affidavit, I'll just point.
Only, no.
So the.
He's right. Only in respect of women, the carry forward process will be applied.
Okay.
Your lordship.
Only for women.
Now,
I just complete your lordship.
therefore, when it comes, your lordship's right.
Horizontal one.
That is, so therefore, because of the application of the law laid down by this honorable court, and we are carrying all of those.
How many candidates are there?
Well, it's
About
320 or something.
Here-
The vacancies are all there.
Just
And there is a
just
stay
make
on
one
future.
submission, your
There
lordship.
is a, my learned friend will just bear with me. There is a future stay of future recruitment also by this honorable court. All of us can be adjusted this.
This 2025 recruitment.
Please follow.
May I just complete.
I'm grateful.
My submission, your lordship.
2024.
May I start thereafter?
2024.
2024.
The lordship would have by
Stayed by
counter
this
in SLP
That's why I
3950.
request my learned friend to just hold his horses for 2 minutes, my lords. I'll just place the facts and after that he can have the court's attention. My lords, that process has been stayed. There are vacancies arising from the 2015 advertisement under which we are claiming. This is the affidavit pertaining to that. The last order passed by this honorable court requiring the state to come forward and to give details was only under the advertisement of 2015. So what my learned friend has pointed out in paragraph 7 are the number of vacancies which are available under that advertisement, and they are now being adjusted here. We are candidates who, my lords, have promptly gone to court, have been agitating this by a wrong interpretation of the rules, and from their own counter affidavit, the rules filed by them, we can, my lords, make an attempt to satisfy your lordships, my lords, that the rule position is very clear. Home guard vacancies which are unfilled have to be filled up, number one. Number two, insofar as the women reservation is concerned, the law by this honorable court is very clear. They will not be followed, carried forward. You have to adjust them on this. So we're carrying all of that. So, my lords, today, my lords, once they have shown that there are so many vacancies, without going into anything, my lords, all of us can be adjusted, and I am only asking for a adjustment.
They're your young boy,
May
young.
I just say, lordship.
They're young boys from
Your
the
lordship,
state. Most of them have become
if
over.
I may,
Yeah.
if I may be just permitted to make two submissions, your lordship. The first thing, your lordship, as I had, I'm asked by the
Your Lordship,
council for the selection commission, your lordship. Out of these vacancies, your lordship, there were several which have been already filled by the operation of the advertisement of that year only itself, your lordship. So, your lordship, their data also need to be incorporated into
Then
this.
why you give this affidavit?
When I said, my lords, not the affidavit, my learned friend just
Then
told
why
me
you
now.
have given this?
After argument, he's coming with this now, my lords.
Your lordship, and the second thing, your lordship is, your lordship would have my counter affidavit, which is in the Mahatab case, 3950.
It is not with him, then he's.
File a fresh affidavit.
Okay,
My
lord.
lords,
But your
that would be
lordship,
unfair of my learned
let's
friend.
have a.
Initially, he told me that he is taking time because he wants to change the affidavit. Now, my lord, seeing
No,
me with the wind and blow.
he might be under the impression that the second new
Yes.
judge is there. So let me take a chance.
No, your lordship. Lordship,
I couldn't have said it with greater clarity. That is all.
No, but see.
The cat is out of the bag.
They have passed preliminary examination. They have passed written examination.
Yes.
They have cleared the interview. They are physically fit.
Document
physically
verification.
Fit.
Yes.
Document verification. You do have vacancies. You do have large number of vacancies. And most of them by now are overreached.
That's correct.
If I may only.
No. Either you argue, we decided. If you want time to file a better affidavit.
Okay, we'll file it,
There's only one thing I wanted to point.
No, sir.
May I just,
1 minute.
yes. Your lordships are not passing in the office today, I know.
1 minute, 1 minute. On the last hearing, precisely what has fallen from a law, we have said that. That is why we asked for this information. So you better file a better.
I'll do that, your lordship.
Simple as that.
I'll do that.
And let it be a win-win situation for all.
Okay, lordship.
That's all. The quietest.
Only thing we have to see is, let us see seniority between them and them, that's about all. That will
That my lords can decide. That's okay.
Lord, I'm not part of this, but Lord, I have filed an application for it. There is a reason. We are home guards. Our non-selection is under challenge. Your lordship's court, my lord, has issued notice in our SL.
let us.
Lord, any filling of the post under the directions in this matter.
They have not passed their
Our
minutes.
SLS.
They haven't passed.
Therefore, I wanted to bring that.
1 minute.
How many home guards are there?
Lord, we are in all, in our petition about 200 home guards.
So vacancies are 2,000. 2,000.
There is scope for everyone.
2,000.
It is pending in court number.
Sir, 1 minute. You want us to send it there?
No, I don't say that.
Then
I said, we are home guards.
we are saying we'll make a win-win situation for everyone.
Very well, Lord.
We'll make sure that you're also accommodated without a judgment from that court. When we are saying that, don't worry.
But
We'll
this
relax.
Vande Bharat Express has got too many coaches. Everybody can be found.
दिखेगा.
One clarification must come on record.
Thank you.
I'm only requesting.
Thank you.
That you can only file an
You have to mention before Honorable the CJI for listing of any matter.
No, I'm not mentioning anything, Lordship. I'm on party here, Lordship. In this,
Then it's all right. Then we'll consider.
I'm only saying, Lordship, that the affidavit is with respect to only vacancies, not that the horizontal reservation cannot be filled up. That's the
Seeks permission to
The
withdraw.
affidavit should be confined to vacancy.
Withdraw the present affidavit dated so and so. Present affidavit so and so. Affidavit dated so and so, filed on behalf of so and so, with the further liberty to file a fresh affidavit
3 weeks, Your Lordship. 3 weeks, Your Lordship.
containing
Notes.
better particulars within a period of 1 week.
My lords, I have not even till now heard what those purported better particulars are. My learned friend says better affidavit, but what better affidavit he wants to say is not something that any one of us are aware
Better
of.
affidavit within 1 week, list on dash.
1 week, Your Lordship, will be difficult, Your Lordship. 3 weeks, Your Lordship. 2 weeks.
Data is with them, gone through everything, they filed an affidavit, at best a correction.
Thank you.
So we can say. I'm grateful to your Lordship and also to Justice Sharma for putting to my learned friend what I couldn't have said to him. So that's very good. Deeply obliged.
You were there in that Bihar matter?
Yes, sir.
So you know the trend.
We've been here enough to see that also. Very grateful for this. Deeply obliged.
Grateful, my lord. Much obliged.
Grateful.
May I please? All the affidavits on record, my lords. Lordship's query whether the regulation is applicable, whether Praneet case is applicable, whether are we receiving any amount from UGC, my lords. Because the affidavit says, my lords, up to 2018 we received grants. Thereafter, no grants from UGC by the university. Only with regard to, my lords, women's development, only we have received funds, my lords.
But you have received funds.
No,
Yes.
and your affidavit, with due respect, is a mischievous affidavit. Where is the affidavit? Please give it to me. I'll point it out. It's a mischievous affidavit. Please come to your affidavit.
My lords.
Where you have said about that grant.
It's para 3.
पूरा file दे दीजिए ना आपने.
No, this is not the affidavit. एक दूसरा affidavit file किया है. In petitioner affidavit. This is an application for an impediment. कल रात में मैंने देखा था.
Filed on 24.
Filed on?
24 1 minutes.
I've seen it yesterday.
Para 3 minutes.
Come to Parath. So
Well,
what you are saying in this?
it respectfully submitted that the petition university is receiving salary grants from government of Tamil Nadu. University Grants Commission is not offering any salary for the faculties appointed in the petition universities. UGC schemes 10, 11 and 12 plans are implemented and faculties are appointed in the plan period. At present, 12 plan, Women's Studies Center is alone receiving the grant. Till 2000.
What is this UGC scheme 10, 11 and 12 plans?
These are the plans
What is
for
that?
development of Melod's travel grant, conference, public grants, appointment of visiting facilities, daycare, adventure sports. That's a heading, Melod's, for each and every.
That's a heading. I'll tell you what it is.
Melod's.
When a plan is sanctioned, 50 posts, 10 posts, 20 posts comes with the plan.
Please,
And in no university, once the plan is sanctioned by UGC, is discontinued.
Melod's.
So this you are receiving grant for number of teachers under the 10th plan, 11th plan and 12th plan. So just to misguide us, you have simply written UGC schemes are implemented. You have not said that you are receiving financial assistance for paying salary to the teachers under these plans.
No.
So that is why I said it's a mischievous affidavit. You are 100% receiving grant for large number of teachers from the UGC and for Women's Studies Center where teachers are employed.
Melod's.
No.
Distance.
I'm so grateful.
Grateful.
I have filed an IE in the matter.
They're not impeding anyone.
Observation to that effect that Your Lordship, we can, on the basis of order, we can.
They are not saying anything, ma'am. So grateful.
Grateful.
Because I'm requesting for a pass over and number 5.
Pass over.
What?
Please, Milord. Milord, this is that matter your lordship said twice sent for mediation, Milord, between the husband and wife.
Requesting for a pass over.
Okay. Pass.
Please, Milord.
My lord, only last night I have received the counter affidavit and I need to file the.
Let's see what the matter is.
It is about the additional charge, my lord. And certain deposition has been filed in the counter affidavit. And there are so many contradictions in that. And I need to file.
No, additional charge, see, counter we'll ignore. But additional charge, section 333 allows, so what is there in it?
No, that is, my lord, after
What is
presenting the
additional charge?
final argument.
Huh?
After presenting the final argument by both the parties.
Your 482 has not been allowed.
Yes,
Thank
the
you.
police inspector with the deceased.
correct.
Has been assaulted.
Yes, yes.
Please, Milord.
My lord, I didn't understand.
Dismiss.
My lord, no. My lord, I have a substantial.
Then argue now. Yeah, that's what we.
Kindly pass over the matter. I will bring my file and I will argue the matter.
No
because
problem.
this is-
No problem.
Sure.
Come immediately because.
But my lord, the problem is that they have filed particular deposition.
We'll ignore that.
Sure.
You argue your case, please.
We are making it clear, come immediately, bench is available only for a limited period.
My lord.
Item 7.
And if you don't come by 12 o'clock, we are.
Dismissed.
Dismissed.
Milords, the state was the counter, Milords.
Which case?
Item 7.
No, settlement was there.
Said, my lords, we've filed the SLP praying that there should be a appointment from this court.
Had we not requested for, just 1 minute. No, sorry. Yes, argue.
My lords, the state had to file counter, my lords. It's not on record.
My lords, I appear for the state. My lords, it's a concurrent conviction. My lords may hear the matter and call for the records. There are a long list of evidence that has not been filed with the SLP, my lords.
No,
My lords, it's a matter of conviction under 420, my lords. There are over 5,000 members
no,
who
1
were
minute.
made to pay.
1 minute. 1 minute. Now, conviction is there, and suppose if you were to pay the money back.
My lords, it's 420. So, with my lord's permission, it can be. But we'll have to trace the complainants and all the members, my lord.
Lordships refer it to the mediation, my lords. The president will file an affidavit and the association.
You have taken money and you have not given plots. Give their money back.
My lords, I was 22 years, my lords, at that age. 2001 was the date of FIR. I was 22 years, my lords. Today I have come, my lords, only out of all 60,000 members, only 105 complainants are there. Even they have filed civil suits, they are in their respective position. They need something, I am ready to pay. So, my lord,
you're not doing charity. You have to return their money.
My lords, we'll do that. That is the petition. That is why I have filed.
Otherwise, go to jail.
I have filed the petition for that.
No, but will you pay? That's the point.
My lords, I left it to the court, my lords, that somebody should be appointed so that they can put their claims there.
Do one thing.
My
What is the total amount involved?
My lords, they are about 105.
Total amount involved.
My lords, they have to put forth their claim, my lords. We
We
cannot.
are only asking you, what is the money involved which you have taken from them?
It's the amounts.
You deposit in this court.
The president would be the best person to say, my lords, the association's president. We'll do that, my lords. The association president, my lords, if it's referred to mediation, he will come and file appropriate act.
These suits have been filed for what amount is what we are asking.
Suits they have filed for injunction, my lords. It's an injunction suit, my lords. It's at page 24, my lords.
You do one thing, we just pass it over. You ask your clients
My lords.
how much money he is be ready and willing. You see, we are conscious of the fact you have been convicted by the trial court,
Yes.
acquitted by the first Supreme Court, and
Yes.
then again convicted
Yes.
by the High Court.
Yes.
And 2 years is what the High Court has
Yes. Yes.
asked you to suffer.
Yes.
Imprisonment. But what is the query point is, should you wish to settle,
Mal.
to test your bona fide,
Mal.
deposit money in this pot.
My,
What is that money which you will deposit here is what we are asking before we even ask them.
my lords, may I submit, my lords? I also have surplus land. If title deeds of the land can also be deposited. Surplus land is there, money.
First,
I'll just
go
find.
out and
I'll
find
do.
out how much of money
I'll.
and how much of land you are ready to.
I'll.
My lords, as per the charge sheet and even the facts recorded in the trial court, my lords, for the year, because this is almost a 30-year-old incident, and the transactions were in 93 to 95, my lords. My lords, at that time, the charge sheet records an amount of 5,35,000 only, my lords. So, however, my lords, this is as per what is on record, but my learned friend may clarify that. And it's also keeping in mind 30 years have gone by since.
Exactly. See, so 30 years, what would be the rate today is what he has to deposit. Simple.
Yes, my lords.
Go out and immediately just
Give me back matter and.
Grateful, man.
And of course, this will be subject to the other side agreeing. We really don't know whether they want to pursue.
I won't.
But suits are pending, they'll all come to an end.
Please, sir. Yes, 2811, the Honorable Court made an interim order, a speaking interim order. I request to have a look at my lord's order of 2811. Para 3 thereof is a request to consider. If I could place it for your lordship's kind consideration. Honorable Court said, inviting attention to the prayer clause C of the plaint, page so and so, it is argued that the amendment sought to be brought in, as is evident from the application page so and so, para so and so, was not for the purpose of changing the nature or character of the suit. It was mere clarificatory in nature.
Let's see page 71 and 287.
Yes, fellows. Because please have a look at page 84, my lords, want to see, my lords?
Yes.
84, lordship, have a look at. This is a part of the plaint, my lords, the prayer C, 84.
83.
Yes, I'll read from 83, my lords. 84 is the prayer C, but I'll read 83 also.
Anyhow, it's all right. That the plaintiff is entitled to get possession of the land.
Yes.
And
the prayer is made, my lords, actually made.
Correct.
No, my lords, then kindly see the application 266. The application is 294, I'm sorry. Where I sought amendment, 294.
What is the amendment? Page 294 that the plaintiff.
Yes, at 295, bottom of 295, just at the top, second line, the plaintiffs are entitled to obtain possession by partition of suits. So only clarificatory in nature. Prayer was already in the suit, my lords. The first appellate court holds in my favor in entirety, but on this ground, kindly see 266, because of which I made the application. 266 is judgment of the first appellate court. 266 para 31 is the request to consider. The appellant plaintiff also, I am for the plaintiff, has a share in the disputed land along with defendant so and so, but he has not asked for any assistance in partition in the claim. Therefore, this court cannot give any assistance to the appellant in getting possession of the land as per his right and share.
What is that the High Court?
But the court says kindly see at 267, 33, on the basis of the above findings, the appeal is partial, the first appellate court. The appeal is partially accepted and the judgment of decree of so and so is set aside. Following decree is ordered that the order of so and so is illegal, set aside, not binding on the appellant, etc. So no order for possession. So the High Court in this application.
High Court says it will change the nature.
Yes. That's the only, my lords.
My lords, allow me 2 minutes time and to show you 3 documents. It is my humble submission that they are arguing a settled position. Their amendment application does not clarify. It seeks to change the nature of the suit.
How?
Yes. Three documents. First, my lords, let's look at their amendment application, page number 294, 295. Page number 294, paragraph number 5, the third last line. My lords, by way of amendment, they want to now argue at the High Court stage that fourth last line from the bottom, my lords, page number 294, that the suit property is ancestral property in which both daughters and the son of deceased Sukya each have 1/3 share. So their first amendment is that this property is not self-acquired, it is ancestral. Just on this point, there are concurrent findings of both the trial court, the first court and the second court. There are concurrent findings. My lords may kindly have page number 149 just on this point. My lords may kindly have 149 of their petition. My lords, page number 149. I'm reading from the last two lines of page number 148, my lords. This fact is admitted by the plaintiffs themselves in their cross-examination. Not only this, Mishri Bai, my lords, she was a plaintiff there, she's a petitioner here. Mishri Bai herself has admitted in her cross-examination statement that the disputed land is not the acquired agricultural land of Sukya. That is a father. It is also admitted that the suit property has been purchased by Sukya from his hard-earned money. Her father was a hard-working person. In this situation, it is very clear that Mishri Bai has admitted the fact in a cross-examination.
We must correct you on one point. Okay. Now, are we to look into the evidence which has been laid for considering the application? 1 minute. All that we have to see is the plaint and the application where it changes nature and character. Now, kindly come to his plaint, page 78, paragraph 2. Here he says, the heirs of Sukya, father of Kallu, includes son so and so. The Amrit died on so and so, before so and so, older Sukya, due to which the heirs of deceased are not defendant so and so. So all that he's praying is that the Sukya's property be partitioned. That's all.
Very well, my lord.
Therefore, he has set up it's not a new.
My lords, on page number 78 itself, the title of the suit was Declaration, Possession and Entry Name in the Revenue Records. The valuation of the suit was as per declaration. It was not for partition. In Madhya Pradesh, my lords, may just allow me 2 minutes.
Are we to look into all this at this point in time, whether the suit is undervalued or not? All that we have to see.
My lords, there are two important things that they did not argue for 18 years. The first is partition. There are two sisters. How are we to know? My lords, they have simply, by a simpliciter way, said 1/3 share, please include it in our amendment application. Now, my lords, the High Court at this stage cannot go into evidence to see how much share belongs to who. There are two sisters. That is something the trial court has to do.
And so therefore, the High Court will, all that the High Court has considered, or for that matter, we have to consider whether the application is belated, is necessitated.
But my lord, how can the High Court at the second appeal stage see what is the share of every person in this case? For that, a partition suit has to be filed. 1/3 share is something that they're claiming here in the Supreme Court and in the amendment application before the High Court 18 years after the trial has already begun. Lord's judgment, if I may just cite my lord, my lord's judgment. My lord's judgment of 2024, my lords, Dinesh Goyal versus Suman Agrawal. It is my lord's judgment in which my lord has. My lords may kindly see paragraph 11 of my lord's judgment.
Judgment is of the court, not my lord.
My lords, the same bench. Now, my lords, in this case, my lords had very well looked into what is the rule and the settled proposition on amendment, right? And my lords had also cited, my lords, the earlier case, which is Life Insurance Corporation. Now, if the facts of the case are completely changed, in this case, acquired property versus ancestral property and 1/3 share, these are two specific allegations, my lord, that requires evidence to be laid.
We again put it to you.
Ji.
Whether the amendment is to be allowed, whether it can be allowed at the stage of second appeal or not, is all that we have to examine. Whether it nature changes, is there any bar that the amendment cannot be allowed at any stage of the? No.
My lords, my only request was, this is the Article 136 SLP that they have filed. And there is no reason, no substantive right that is extinguished. The High Court is still going to look into the merits. My lords, let the High Court decide on the merits. If they still have a grievance, their remedies are not exhausted. So why indulge them for procedure at this stage, my lord? That is my only humble submission.
So whether the further evidence is required or not is for the High Court to consider.
But my lords, the High Court cannot be asked to look into, and which is why the High Court rejected it. My lords, we just have page number 3 and petition, my lord.
And counsel to the party, we will consider you that the.
My lord, just one last line, my lord. My lords may kindly look at one line of the High Court order, page number 3. Page number 3 of the petition. My lords, the first paragraph, last line. The High Court says specifically, my lords, that the proposed amendment would
invariably change the nature and character.
For partition and separate possession. So I am saying this requires dismissal at a threshold. That is my humble submission, my lord.
Would you allow us to now?
Yes, very well, very well. My apologies.
Chamberlain. Allowed him to raise the.
Please, Your Lordship. You must obey, Your Lordship. I'm grateful to Your Lordships. Please.
Yes, my lords. I beg to appear on behalf of the learned ESG, my lords. We filed our rejoinder subsequent to the last order. My lords may post it for arguments any day.
Sorry, say that again.
My lords, I beg to appear on behalf of the learned ESG. Pursuant to your last election, we filed our rejoinder. My lords may post it for arguments on any day.
No, what is there to argue?
My lords, counsel for respondent is appearing to VC.
Please, my lords, I'm there on VC. For some reason, the video is not switching on.
That's okay. We can hear.
Lords, there are serious charges of corruption and sexual harassment in this case. The respondent has been awarded the penalty of compulsory retirement. Soon after, on submission of his pension papers, the pension was reduced to 2/3 of the pension amount by the competent authority, which is the Lieutenant Governor in this case. The competent authority continues to be the same. It's a part of his responsibility and a statutory penalty which has been imposed pursuant to Rule 40.
The Rule 40, does it say that gratuity in pension is to be forfeited?
It allows reduction. It specifically allows reduction of gratuity and pension in cases where compulsory retirement has been penalty.
My lords, once the disciplinary authority has passed the order.
You were not called
yes, my
upon.
lords.
You were not called upon. Please.
Which rule says that in case of compulsory retirement, pension and gratuity will be forfeited?
Will be subject to reduction, my lords.
Which rule says it will be forfeited?
Rule 40, my lords.
Where is that?
It's my lords. It's extracted at page 3 of the impugned order. My lords may allow me to read it. Compulsory retirement pension. A government servant compulsory retirement from service as a penalty may be granted by authority competent to impose such penalty, which is the Lieutenant Governor in this case. Pension or gratuity or both at a rate of not less than 2/3 and not more than full compensation pension or gratuity or both admissible to him on the date of his compulsory retirement.
So that order should contain all this. Kindly read further. From the above, it is.
From the above, it is abundantly clear that reduction in pension or gratuity as contemplated under the said rules is not an automatic consequence of the necessity of compulsory retirement. My lords, this is our argument.
No. There has to be an order. You have.
My lord, that order was this matter. Once the Pay and Accounts Department considered the pension papers, it was reverted back to the Lieutenant General, who, upon consideration.
No, he can't pass orders in pieces.
My lords, once the charges have been established.
It should have been part of the main order only. That keeping in your misconduct, the gravity of charges against you, the competent authority is now reducing your pension all in view of rule.
I quite see that, my lords.
Then the High Court has rightly dismissed it.
There is, my lords, it's our humble submission that seems to be a bit of a technical ground. In that, my lords, once the charge.
Unfortunately, people succeed on technical grounds.
I quite see that, my lords, but once the charges have been established, my lords,
No,
my lords, what's the
positive.
nature of the charges? Sexual harassment, corruption.
You could have very well dismissed him for this.
My lords, dismissal was granted, compulsory retirement was granted.
It's not dismissal.
Compulsory retirement, my lords.
Compulsory retirement is not dismissal, madam. You could have dismissed him from service.
What my lord is saying is that if the charges were so serious and severe, in your wisdom, rather than allowing him to step out, you should have thrown him out, which you did not do so. So therefore, as an afterthought, today you cannot say that the gratuity in pension is also to book. Thank you very much. You argued very well. What's your good name?
My lords, Harshita Chaubey.
We appreciate the efforts, the submissions made. While fully appreciating the submissions made.
Yeah, Harshita was fighting with great force.
We find ourselves unable to be persuaded in allowing the presentation.
Grateful, my lord.
Grateful, my lords.
Item 10.
I take you for the petitioner minutes. As per the office report, the respondents have been served.
No, sorry.
As per the office report, the respondents have
Forget about the office report.
Minutes.
We often say that we issue notice for various reasons.
Minutes. This was a matter, Lords, where I have filed a fresh suit. But prior to that, I have moved an application under Order 23 Rule 23 Rule 1 for withdrawing my counterclaim. Pursuant to that, I have filed a fresh suit seeking my share in the property. That was rejected by the learned trial court under Order 7.
Finally, come to page 43 and
Any liberty was granted to you.
With all due respect, Lords, the order says in terms of the application. Please have an exhibit P3 at page 43 for a while, Lords.
Your application is, where is your application?
My application is at
101.
Lords. This application was filed by, this is under Order 7 to 11. Lords, we just have the initial application filed by me for withdrawing the counterclaim.
Where is that?
Lords. Please come to page 40 in exhibit P2.
40.
The operative part is at page 42. If Lords permit, may I read?
While reserving the right to represent the case if a new dispute arises.
Now, please come to page 44, what the learned trial court records. So this is a dispute between the brother and sister. Page 44, if my lords have that. The operative part, I read, on the basis of the application regarding the counterclaim, the application under Order 23 Rule 1 is accepted and accordingly dismissed. Therefore, it was on the basis of the application. In the application, I have specifically stated, I reserved my liberty.
No, just one. Let's read the page 43 together. The case record was perused. From the examination of the case record, it is clear that after submitting the application, defendant Mullabai did not produce any evidence. From the application submitted on behalf of the defendant Mullabai, it is clear that she did not wish to withdraw her counterclaim due to any procedural defect that may cause its failure, but rather because she does not wish to seek any relief from the plaintiff.
Is a plaintiff. For the reason why I said so, let me just have my application for a while.
We have seen
the application says that since because there could not be any in future, if any, since the parties were living with each other, both the brother and wife, the brother and the sister, and in order to maintain harmony between the parties.
The only difficulty which is coming in this way is these 4 lines at page 44, top 4 lines. That's the only thing. Because it doesn't say simply that the application is disposed of in terms the application is allowed in terms of the prayers made in the application.
Well, see, learned trial court with all respect, records on the basis of the application. So if I say on the basis of the application, that includes whatever I have stated in the application.
You are the.
I am the sister. I am the sister, and Jhansiram is my brother. My share in the property is 0.49 hectares.
0.49
hectares.
Long pending dispute, small area involved.
Therefore, my lords, I was under the impression if the respondent would have been appearing in this matter would have been sent for mediation, but he chose not to appear.
Then what do we do?
Lords.
Thank you very much. Thank you. We're not replying.
Lords, that was all respect, lords. The application was rejected only when it was.
It doesn't, it's not like
Lords.
May I please, Your Lordships? Lordships, I've been led by learned senior Honorable Kaushik sir, but
This is infectious lady.
before my learned friend will say with regard to the infectiousness, let me at least put forth what the issue is that, Lordships.
Let her say.
Lordships, the present SLP is as against the challenge of the order under 227, Your Lordships. The High Court, on 3 occasions which I had presented that this RLTOP is not maintainable, was not considered. As against that only I have come over here, Your Lordships, before the Supreme Court.
Tenant.
Your Lordships, I am not a tenant is what the dispute is. Therefore, I had filed a suit, which is a proceeding wherein issues have been freed and PW1 has not come into record.
Good, claiming that you are owner by way of adverse possession.
I bow down, Your Lordships. Lordships, over here. Lordships, but that suit is pending. My humble submission is, Lordships, may I say this?
There's a person who's claiming adverse possession. There's a person who's holding clear title.
No, Your Lordships, that is what. They are not holding title. My submission is not even a single document. Your Lordship may take the rent control proceeding petition. It says that for arrears of rent. But whereas over here, Your Lordships, if assuming they should have filed it, it should be on only 21(2)(a). Your Lordship, last occasion we had circulated the act also, Your Lordships, for your kind perusal. Only under 21(2)(a) they ought to have filed. Rather than 21(2)(b), they cannot file. Your Lordships, may I say this, Your Lordships?
You simply withdraw it, saying that the
appeal is pending.
Your Lordships, appeal is pending, Your Lordships, but as far as this issue is concerned, even RLTOP cannot decide on the title, Your Lordships. Lordships, on title it cannot be decided is what my humble submission.
Is this ground in appeal?
Lordship, we have raised it that.
Raise it, then please argue it.
Because the reason under 42, it is barred to look into that issue, Your Lordship. For a moment, for the provision alone, Your Lordships.
Your decibel level just low.
Your Lordships, I'm sorry. Lordships, 42 provision alone because.
You are a tenant.
Lordships, I'm disputing it, Your Lordships.
But courts have held it so.
No, Your Lordships. May I say this? The agreement, not even an agreement, one receipt with the brother of the tenant as holding.
That you have filed a suit for declaration.
Yes, Your Lordships.
Of title on account of adverse possession speaks volumes about your conduct.
Lordship, may I say this then, Your Lordship? Let me have this. Let me contest the suit, Your Lordship, because my.
Please, we are not touching the suit. The suit is not subject matter of this.
It's not a subject.
Please.
Lordships, but with regard to the title, Your Lordships.
No, very sorry.
You want to withdraw or dismiss?
Let me just.
You have filed an appeal and please raise all grounds in that.
Lordship, they cannot decide that issue is what my humble submission.
The court will pass an order on that ground.
Well, fine, Your Lordship. Only to that limited extent, Your Lordship passes because otherwise they'll not entertain RLTOP or that is continuity appeal.
Please challenge that order. Next case, please.
Item 12. Lordship, let me withdraw it, Your Lordship.
Takes permission to withdraw. Simple.
Item 12.
Yes.
Please, Lords. Lords, it is a dispute between legal heirs of brothers and sisters.
Who are you?
I'm Milord's wife and legal heir of Shivalinga, whose favor 2 sisters.
What is your claim which you have set up?
Milord's, my claim is I'm in adverse and ouster possession since 1980.
Can a co-owner be an adverse, take plea of adverse possession?
Milord's, in my favor in 1980, delinquent rights were transferred in my favor.
Then you can't be in adverse possession. Either you're owner. See, you're either co-owner or you're an absolute owner by virtue of your own right, but you can't take such destructive.
That is a lot more triggers.
Lords, during the life, Lords, one submission.
All 3 courts have decided against you.
Item 13.
I appear in 13.1 for accused number 4.
My lords, this is a case under section 302.
What has happened, my lords, in this case?
You filed an application for,
This is an SLP against conviction, my lords.
yes.
It's coming up for the first time. I'll just give my lords a very brief introduction to the case and the key
Is there
point.
no eyewitness to it?
My lords, there is an eyewitness as per them who has a motive to implicate me. But be that as it may, the defense witness who we led, my lords, is admittedly the first person to inform the police about the offense. The police comes to the spot at his instance. They record his statement. He truthfully says that the deceased had a knife in his hand. There was a quarrel, and in that process, the deceased is assaulted. The eyewitness, so-called eyewitness, my lords, his statement is recorded more than 2 hours after DW1.
There are two, please kindly see, there are two eyewitnesses. Okay, let us discredit the complainant. PW5 and PW1 are there.
My
They are
lords,
the eyewitness who.
PW1 is the complainant. And so if we are to discard PW1, my lords, we are left with PW5.
Correct.
Now, even for PW5, my lords, his statement is recorded much after the defense witness. Secondly, my
How
lords,
to impeach the credit of this witness then?
my lords, he also,
Can you see what you have cross-examined him on?
my lords, he also,
His presence is not in dispute. Having witnessed the occurrence of the incident is not.
my lords, but he has also lied about the fact that the deceased was also holding a knife. My lords will have to compare the versions of DW1 and PW5. They are both.
DW1.
My lord,
Where is DW1?
DW1 has been annexed at page 267. Annexure 12. The IO admits, my lord, that he is the person who called at 1:20 a.m. and his 161 was recorded. My lords, these two witnesses will have to be compared in terms of whose credibility is more. Further, my lords, in my learned senior's case would be different, but in my case, there is the additional fact that my name is not in the FIR anywhere.
You are for accused?
Connected matter, accused number 4.
Number 4.
Sachin.
What do you have to say?
Yes. My lord, the entire evidence, my lord, in this case, my lord, has to be appreciated considering the fact it's a case of gang war. The two rival gangs, my lord, have clashed. As far as PW1 is concerned, my lord, he is already an accused, not only PW1, but the deceased himself was already an accused in respect of a case of attempt of murder of accused number 1. And they were released on bail just a month or so prior to the incident. Then your lordship will finally see, my lord, it's a case of having 3 eyewitnesses. DW1 was supposed to be examined as a prosecution witness. He was not examined as a prosecution witness. That's the reason we examined him as a DW1. Lord, he is a manager of the concerned bar who knows all the persons, my lord, the accused as well as, my lord, the witness on the deceased, because they were frequent customers in his bar. They used to come to consume liquor frequently. Lord, he categorically says that PW1 and PW5 were not present at the incident, at the spot of incident. Then there are several other aspects. Your lordship will kindly see that as far as PW1 is concerned, my lord, when he says that though he was accompanying, my lord, the deceased, when the incident occurred, he had crossed the road.
Where is your 330?
Yes, 313. In additional, no?
My lord, my 313 is at page number.
No. Yeah, PW4. He has a better case than you.
Yes.
My lords, we have the identical case.
No, you are the person who is.
My lords, if my lord is going to believe the eyewitness, we
We have to believe what is there in black and white. With due respect.
My lords,
Because they are not in front of us.
My lords,
in front of us, this black and white is there.
DW.
So we have to lie.
If I would,
With due respect.
I would respectfully submit, my lords, DW1 is also present at the spot.
Doesn't mean if 10 people are present on spot and the police only 2 witnesses have been examined, it doesn't mean that testimony of those 2 has to be ignored. It doesn't mean that.
My lord, certainly not. But then DW1's
Even 1 witness is good enough.
But my lords, DW1's testimony should also not be ignored, and my lords will have to go into that and compare the 2 versions. My lords, this is a witness who is the first person to call the police.
Then who has killed him?
My lords, DW.
All right, all 5 of you have not killed him. Then who has killed him?
My lords, in fact, PW1's own.
He has stabbed himself.
My lords, if I may respect,
What is this you're talking?
PW1's own testimony is that this is a man with a large number of cases against
He'll start stabbing himself.
and a large number of
That,
my
that
lords.
is why I want to know who he will start stabbing himself, seeing enemies in front of him. It is just not possible.
My lords, the other people have more.
Other people have stated against you.
There is a 330.
That is not on record. I will file it.
No, we are not.
And my lord, I have the hard copy. I'll just read
Just
it.
show it. Just
Yes,
show it.
yes.
You want to see the defense you have taken?
Yes, yes. The defense is
Not
that
taken.
My lords, other defense that I have taken is that none of the witness originally named me.
We have seen your ma'am page 265, your defense.
he says he was not there.
My lords, if I may just clarify, they say that I am a bittu. The person.
क्या हो गया?
नहीं बोलते.
अच्छा.
See, the moment you take that I was not present, I was at a particular place, the onus and the burden shifts on you.
My lords, I have led.
1 minute, ma'am, please.
Yes, yes.
You know.
That's true, my lord. That's true.
So what is the evidence you have led to establish this?
My lords, if I may respect.
No, please.
Question is for me.
Sir has to respond.
Yes, yes. My lord, that's right, your lordship. My lord, there is no evidence to that effect. But your lordship will kindly see himself. My lord, I am just, my lord, assailing the evidence of PW1 and PW5.
Thank you, sir.
PW1 and PW.
My lord, may please wait a moment. My lord, may hear the other. My lord, my name is not in the FIR.
Thank you, ma'am.
My lord, may just consider this. They are saying that a certain bittu.
We've heard you enough.
My lord, may I simply request? I'm requesting, my lord.
We have seen all the testimonies, ma'am. We're telling you.
My lord, may I make one request? My lord, may keep this matter tomorrow. Give me two. My lord, may consider this one argument. My lords, please. I am not named.
My lord, item 6.12, my lord. Achha, oh, my lord.
Item 13, I think my argument is not yet complete, Your Lordship.
Okay, no, no
Yes.
problem.
Yes, I'm grateful.
What is?
Go.
See, we put it to you
Yes,
that you've taken a plea of alibi.
correct.
Now, if you have taken a plea of alibi, then you know the law.
Yes.
It is for you to establish that.
Yes, my lord. Now, my argument is that even if, my lord, there is no evidence, my lord, corresponding to the defense taken, my lord, under 313, under section 165 of the Evidence Act, my lord, a duty is cast upon the concerned court.
Correct.
Yes, and my lord, that issue has been considered by this honorable court. That
No, we have, just 1 minute.
Yes.
For a moment, there is no doubt that you are innocent and the prosecution has to establish the case beyond reasonable doubt.
Correct.
We have not, I mean, on that proposition, you need not cite any law.
Yes.
What we are saying is that evaluation of the testimonies of 3 witnesses, DW1, PW1 and PW5, when we compare, we find the testimony of PW1 and 5 to be more convincing, satisfying.
Yes.
More so in view of the fact that it has been correctly appreciated by the courts below. And we do not find any perversity in that. That is one limb of the argument.
Yes.
The second limb of the argument is that now you have taken a plea of alibi.
Yes.
Were you not obliged to independently establish that alibi? Because unlike her, you have not maintained silence. She has maintained silence. You said that, no, I was at X place. Now, if you were at X place, you didn't say that I was not there. Your categorical statement is that I was at X place. If that is so, then under the Evidence Act, to establish that fact would be on whom is what we are asking ourselves.
Yes. Now, my lord, for a while, my lord, this plea of alibi, my lord, kindly ignore it for a while. Now, I am on the point of credibility of the evidence of PW1 and PW5, the so-called eyewitnesses, as against me. And it's not only as against, my lord, the petitioner who is accused number 4, but also against accused number 5, though I am not appearing for him. Because the PW1, my lord, in his evidence says that initially the attack was carried out by accused number 1, 2, 3. He says A4 and A5 came later on and joined them. So there also, my lord, this is very vital.
For what?
My lord, I came later and then assaulted. Obviously, my lord, he obviously says assaulted. So now the point is that, as my argument, I started my argument with the case that, my lord, it's a case of gang war, and, my lord, evidence, my lord, will have to be very carefully examined. Considering this angle, my lord, there will be every possibility, my lord, to involve the other person from the other gang or say other group. That's the reason, my lord, the evidence of DW is very vital. As I said, my lord, he is a manager, my lord, working in the bar. He was well acquainted with all the accused, as well as, my lord, the deceased, as well as, my lord.
We have applied our mind and sorry, sir.
So, my lord, as far as, my lord, my client is concerned, my lord, there is enough evidence. My lord, even accepting the excluding this plea of alibi.
Thank you, sir.
My lord, may I apologize? Just may I say 2 things, my lords? I will not repeat. Give me 2 moments, my lords.
We will just, do you wear a watch?
I do, my lord.
Uninterrupted, your iPad would be having uninterrupted 5 minutes given to you. Please, proceed.
I am most grateful, my lords. I am not going to repeat 2 things, my lords. Firstly, the 2 eyewitnesses that my lords are convinced by PW1 and PW5. They say, my lords, they name a person called Bittu. They do not take my name. My name is Suraj Singh. My lords, it is not put to me in my charge that my name is Bittu. It is not put to me in 313 that my name is Bittu. Not a single other witness, my lord, says that Suraj Singh was also known as Bittu. For the first time in court, my lords, the witness says that he is also known as Bittu. Whether in fact, my lords, I was actually present at the offence, given the belated manner in which my name is coming up, my lords, is something that my lords would have to consider.
We have considered. What is your cross-examination on this issue?
My lords, both PW1 and the IO, I have cross-examined saying that I was not known as bit 2. I have cross-examined the IO saying nobody told the IO that my name was bit 2. My lords, imagine the witness says a bit 2 was also present. He does not give my address. He does not give any indicator to the fact that I am bit 2, and he claims to know me right from the beginning. He doesn't even say bit 2 was the pet name of the person. I have cross-examined PW1 and the IO on this point in great detail. And my lords, it is not put in my charge or in my 313 that my name is also bit 2. My lords, they have done nothing to say that the person initially named.
Point well taken. Don't repeat. You
Certainly.
weren't there.
My lords, the second point, my lords had said that even if one was to discard PW1 because he has enmity, my lords, this is a point where PW5, the eyewitness, and DW2 would have to be compared. The normal parameters of seeing whether an eyewitness is credible, my lords. Did he promptly inform the police? And has he told the whole story? Now, my lords, on promptly informing the police, DW1 is better because he is the person who calls the police and says, come here, a fight has taken place. The deceased is lying dead. Has he told the whole truth? PW5, my lords, lies and says that the deceased did not have a knife with him. It is only on cross-examination and confronting him with the other documents that he is forced to admit that the deceased had a knife with him. On the other hand, the defense witness, right from the beginning, is saying the deceased had a knife. He was having a quarrel. They assaulted him. He tried to assault. They were more in number. They assaulted him and they ran away. PW5, my lords, is friends with PW1 and the deceased who have enmity with my group. DW1, on the other hand, is a neutral witness who knows everybody equally.
What does DW1 say?
My lords, he says that he knows all these people. The
Yes.
deceased was at the bar. He stepped out. Some other group came, not us. They were quarreling with the deceased and they assaulted the deceased.
Thank you.
My lords, my only request is give us an opportunity to read the evidence and compare it, my lords.
Thank you, ma'am. Thank you.
But only one, I'm sorry, my lord, because when two lawyers are, I just missed one point.
Two lawyers, we have independently.
No, my lord, I just, my lord, I want to highlight one mandatory provision. My lord, under section 157 of CRPC, whenever any FIR is, my lord, registered, my lord, it is mandatory that it should be, my lord, informed or sent to the concerned magistrate within 24 hours. This is very important. And admittedly, my lord, this has been done. That's the reason I say that.
Too late in the day. Too late in the day.
Short adjournment. Then arguing counsel is out of.
You have to argue, please.
The arguing counsel is
have only been handed
not
to the
in
brief
city.
respondents. So if they have asked for an adjournment, they have apprised me yesterday that they're seeking adjournment.
They didn't mention to the court.
They mentioned it to me, Manoj. That is why.
They didn't mention to the court. Yes, please.
No, the arguing counsel is out of city. I have no idea about this.
I will have it tomorrow, Manoj.
Lord,
Tomorrow.
Okay.
Very good.
grateful.
Very good.
And he's grateful for asking. Very simple.
Counsel, we'll pass over a file. You be ready. We'll give a file to you. You should have mentioned to the bench yesterday. They won't care.
Morning, I got the from the arguing.
Don't feel him. Now, tomorrow in the morning.
May I please, your lordships? My lords, I'm appearing on behalf of Gram Panchayat. My twofold arguments are this, my lords. We were not in the cultivations prior to January 1950. This is what the Holdings Act clearly says, my lords. The second argument is this, my lord, that there is a judicial order, page number 31, my lords. 30th of March 1967. Please see, my lords. In this order, they themselves have moved an objection that the earlier land which was to them were not fit for cultivation. Therefore, another piece of land was given to them. So, my lords, in my humble submission is this, that by piece of evidence that
Yes.
well, they have to establish by way of evidence that they were in possession prior to 1950, 26 January 19, which they have not established. This is what electors have observed in this order. This is what commissioners have also observed in this.
This is exactly what they
I could have ignored, my lord, this page 31. Please see page 31, my lords.
31.
May I read it, my lords? The second paragraph. After hearing the petitioner thoroughly, I have gone through the record and that the only objection of the petitioner is with regard to the area of his tenancy under the Gram Panchayat. He says that the area given to him now in rectangle number 10, etc. is unfit for cultivation. He should be given some other area for the Gram Panchayat, which can be given to him. Therefore, in order
What
to
is the extent of area?
my lord,
Brief canal. इतने छोटे किस्से लोग
they can be declared as owners, my lord. They were
no, they are not praying for any charity. They have established their right.
Please, Your Lordship. This is item 16.
Yes. Yes.
My Lord, this is a motor vehicle accident case. This is a death case wherein Your Lordship had recalled the order wherein the SLP was dismissed.
This was in which combination?
Before Your Lordship and Justice Koteshwar Singh.
लिस्ट इसको करिएगा मैम कोटेश्वर साहब के साथ हम कब बैठे शाम को लंच कम आफ्टर लंच कम आफ्टर लंच
मेरा भी बहुत म्यूजिकल चेयर टाइप का
तो हमारे तो आफ्टर लंच आज आइटम 1
Very good.
Item 17.
Lord, in item number 17, my lord, yesterday I have received the typed copy of one annexure, my lord, filed by the respondent. Now, my lord, I need to check the veracity of this annexure from a department because they say that there is one group O. On instruction, I say there is no group O. This CGA policy was only for group C and D. No group O exists, my lord, in our
That
department.
maybe in the typed copy it's come as O, but otherwise it's D only. Maybe the type.
D only.
My lords, it's D. And this document was a part of the High Court record also, my lords. And they never raised any objection to that. This was placed in the High Court.
Today may not be ready perhaps.
But it's no, my lord, please keep it on.
List on as per the respondent list on coded notes.
Deeply obliged. Item 18. There may be an error in the typed copy. If it is, then
There's no group O.
I'm
Deeply obliged.
My lord, this the High Court has considered the income on the lower side. In this, my lord,
So what about the service?
Services complete, my lord. I was appointed as a Midas.
No, did you write to them?
Yes, my lord.
Where is your affidavit that you've written?
On the last day, the respondent number 2 company appeared. They filed a counter affidavit also.
Who's for Manjeet Chawla?
My lord, we have filed the counter affidavit as well.
What do you say?
My lords, in this regard, my lords, they have not filed their any income. My lords, if my lords may have the paper book, my lords, they, may kindly see one that they have not adduced any evidence at trial regarding their income. MECT list of documents is on page 60. My lords, may have page 60. not even a single whisper of how much he earned, not even his bank account statement.
What is your income? You were serving abroad, no?
Yes, my lord, but
Where is the evidence that something, not evidence, but even something to show that what is that you have?
Unless there's a visa, if I may interrupt. Unless there's a visa on page number.
No, visa doesn't help him, no? What was he doing there? How was he? What was he employed as? And what was any statement on record is what we are saying. Forget about documentary evidence.
my lord, we have produced the
Where is that?
ID card in which in company which he was working.
Where is that?
It is in page number
मैम ये रिकॉर्ड आया क्या?
33.
MSCT का. What was the basis on which the High Court determined your income?
My lord, it was literally, totally on the unskilled worker. He was considered as an unskilled and he was
Minimum wages.
given the order. And
8,000 नहीं ना unskilled worker नहीं. अभी
My lord,
हर
ज्यादा मिलता होगा उससे.
my lord, the lady is at 28 years.
That doesn't matter.
He
We
was
are only
he was working in which country?
Dubai, my lord.
Dubai.
ज्यादा मिलता होगा.
In 2015, what would have been his notional income there?
Well, they have not produced any application under Order 41 Rule 27 for the High Court that they have moved regarding this income certificate.
So one thing you share with your clients, any document, any.
My lord, so illiterate, the lady who has her husband, she's illiterate, my lord, she can't travel Dubai.
No. This person must be having some bank.
My lord,
Yes. And he must be sending some money to the lady also. So if he's sending 25,000 per month, it means his income is more than 25,000 per month. So you have to do some homework. He was in Dubai, she was in India. He must be sending a month money every month.
he was recently married, my lord.
Recently married, कुछ तो अपने parents को भेजता होगा. My lord is giving you a clue. Why don't you take it?
Yes.
Find out from the family something.
Is it a referred brief? Oh, ये होगा ना.
यहाँ तो यही होगा. You are not from Telangana.
Oh my lord, I am from Karnataka.
Karnataka.
What do you say, Michaels?
My lord, there's only one document on page 35 which only says that Subhash Manikappa was to be